what we are doing is in defending the integrity of the court, because this is very, very important. When once a court makes an order or a judgment, that judgment must be obeyed. However, whether weak or strong, however the nature of the order of court is, it must be obeyed. And it is a fundamental rule of law that every order of court must be obeyed until it is set aside. So what the applicant is pursuing here is that the defendants, the respondents, should comply with the order of court. Their failure to comply persuaded the applicant to bring this application. What we are doing is reinforcing the powers of the court and the rights of the litigant, where to reap from the fruits of their labor coming to court. And in this case, it is very clear. The order of court was restraining the respondent from doing certain things, but they went ahead in violation of the order of court to continue. Our submission before the court was, look, it's an afterthought, because he is seeking equitable rights from the court. Equity, is seeking equity from court. And it's clear that he who seeks equity must do equity. And in this case, the Anambra State High Court judgment is a court of coordinate jurisdiction with the FCT High Court. And the FCT High Court came first. And in equity, you know, where there are competing rights, the first in time will always prevail. And we are confident that the order of FCT High Court was first in time before they obtained whatever they obtained, which even the applicants were not even a party to those they were not even aware of the proceedings in Anambra. But the first defendant, Oye, was a party in this suit. It is not even in the place of the first defendant to say what the plaintiff have brought to court. Simply, what the plaintiff brought to court, the substantive suit, that is the originating summons, was on complying with the decision of the Supreme Court. Simple. You understand me? So the issue of whether APGA, the question is, was APGA a party in at the Supreme Court? You know, all we're saying is, court, please give effect to the judgment of the Supreme Court. That was the case of the applicants here.
Like you actually said, they had a loophole which they exploited. It's actually not correct, because APGA as a party, the name of a party, was not an issue in conflict. People were parading themselves as the national exco of APGA, and as duly elected exco recognized by the party. We wouldn't have added APGA as a party in that particular suit in any case, because APGA as a political party, there was no issue of conflict in any case. And then secondly, the suit in Oka, like my learned colleague just said, I mean, for a suit or a judgment of a court to be binding on another party, there's a principle of estoppel. In estoppel, the parties must be the same, the subject matter equally must be the same. It's like rubbing shame on the court that gave the order, and we are saying that these orders have been disobeyed, and they have been trying to rigmarole all this period to see that they don't attend court. They know very well that they violate the court order. If they are claiming that the Oka judgment is equal to the one of Abuja, why did they go to Court of Appeal? They ran to Court of Appeal later to make sure that they legitimize what they did. The Court of Appeal threw the application off. Instead of them to go to Supreme Court, they didn't go. By so doing, it's an abandonment. When they have resigned to faith.